Module 3, the topics involved, the liability that you as a server can be accountable for. Information to be covered in this unit. Number 1, third-party alcohol liability lawsuits. Number 2, the potential legal consequences of overservice. Number 3, what can you be sued for? Number 4, civil lawsuits for serving a minor. Number 5, who can sue you? Number 6, damages you would have to pay. Number 7, criminal liability. Number 8, how to protect yourself from a third-party lawsuit. Number 9, using a logbook. Number 10, alcohol serving policy. Write this down, please. Third-party alcohol liability lawsuits. Third-party alcohol liability lawsuits. There are 3 parties involved in a third-party alcohol liability lawsuit. You get the first party is a drinking party, that is the customer. The second party is the serving party, that is you in the establishment. The third party is the person outside of the alcohol transaction, the person who was injured, the property damage. Here's the way it breaks down. Mrs. Jones comes into your bar. She sits down and she serves her some Merlots. And after a while she said some Merlots. She couldn't quite get the word out of her mouth. It comes out something like, lots of Merlot, please. Like, hey, drunk lady, you're done. Dang that. She's like, excuse me, I'll tell you when I'm done drinking. I'm going someplace else to appreciate my business. And she gets up and leaves. And you do nothing to stop her. Now, you might make a comment to her, like, are you okay to drive? And Mrs. Jones says to you, yep, I'm fine, and she heads out the door. Well, she's driving around the road, and here comes Mr. Smith, and she crashes into Mr. Smith's car and hurts him really bad. Here's what can and probably will happen. Mr. Smith will sue Mrs. Jones for hitting her. Then Mr. Smith can sue you and your establishment where you're serving alcohol for over-serving Mrs. Jones. These are not new alcohol liability laws. They go way back into England. They're part of the common law. Here's a quick trip to law school for you. A tortfeasor, a tort is a civil wrong. The category that you as a server can fall under is negligence. This tort will require 4 elements for it to be completed. One is a duty to another. This is created by common law. Common law is decided as the common to the area of where you reside that if you served alcohol to someone to the point of visible or apparent intoxication, you should get this person to safety. Yeah, you call them a cab, you call their friend, their spouse, or they just sit there until they get sober. Remember, if somebody's intoxicated in your establishment, not causing a problem, purchasing, possessing, or consuming alcohol, they're welcome to stay. Number 2, was there a breach of this duty? Did the server of the alcohol do nothing to stop that person from driving or walking away? Number 3, probable cause. Is it foreseeable that this individual who is now intoxicated, that if they drove or walked away that something bad could happen? Obviously, yes. And number 4, you have your actual damage, your tangible damages, such as property damage, lost time from work, medical costs, etc., as well as the intangibles, i.e. pain and suffering. A third-party liability lawsuit is this. If you overserve somebody alcohol and they injure somebody else or cause property damage, there's a good chance you can and will be held accountable in a court of law. All of those involved in the alcohol transaction can be named in the lawsuit. The manager, the host, the hostess, the valet, the attendant, the bouncer, etc. will all be named in the lawsuit. 51% of the jury can be enough to convict, and only 51% of the burden of proof has to be placed upon you. A law journal reports that 80% of these lawsuits will be settled out of court for $100,000 or more. The cases have multiplied by 300% in recent years. Third-party liability lawsuit is this. If you overserve someone alcohol, you can be held directly accountable. So don't overserve. The problem is it will happen. When someone drinks alcohol, they're going to become affected. It could be because they started at home. They are mixing it with drugs. They have a low tolerance. There are a lot of different variables which can make it difficult for you, a server involved in the service of alcohol, to protect yourself from a potential third-party lawsuit. What are the potential legal consequences of overserving? You have 3 of them. You have licensing consequences, civil consequences, and criminal consequences. Licensing consequences. You lose your livelihood, your employer loses his license also. Civil consequences. You lose your home, your life savings, and whatever else you've accumulated. The licensing consequences are relatively straightforward. If you're caught, you lose your license. The civil consequences require more in-depth treatment. When looking at the civil consequences, there are a few specific questions you need to ask. What can I be sued for? Who can sue me? And what types of damages will I have to pay? What can I be sued for? Since 1933, the law in the state of Washington has been as follows. No person shall sell any liquor to any person apparently under the influence of liquor. This is the same standard that will be used in a civil suit against a server. Courts analyzing that language have stated that the relevant question is the appearance of the person at the time the alcohol was served. Important things to remember. You can overserve someone even if you have no evidence that they've had anything to drink beforehand. The only question is whether they appear intoxicated. Courts have pointed out that the intoxication need not be obvious. Any person who seems intoxicated may not be served. Now, seems intoxicated is a little dicey. Basically this, the ones who come in, they have one drink, suddenly they're intoxicated, you now realize they've been drinking someplace else before. Problem is, you have overserved them. Then you got the old seasoned pro, the one who sits there and puts one drink down after another. Even though as many drinks as you served them, you know they should be buzzing, and they're not, that can come back and bite you. We've been talking a lot about drinking and driving. Actually, slips and falls are a much, much bigger issue. It's the person gets drunk, they go in the bathroom, they slip, they fall, they crack their head, they want to sue you for an unsafe condition. Then you got the boys who want to settle this outside, the old-fashioned way, little fisticuffs. Well, if you serve someone who is obviously intoxicated and that a person assaults someone else, you will be liable to the person who is assaulted. In 1997, a Washington State court case saw where two men got in an argument in a restaurant bar. They were told to leave. They went outside. The fight escalated. One man bashed the other man's head into the pavement where the man suffered serious brain damage, memory loss, and chronic headaches. The restaurant was held liable for those damages, which were in the millions. Now, what happens if you serve a minor? Well, serving any liquor to a minor can lead to a civil liability lawsuit for any foreseeable act that the minor does. You can even be held liable to the minor if that minor hurts himself or herself. But you can protect yourself from liability if you check the buyer's identification and have the buyer sign a proper certification card.